Hey everybody, welcome to my channel. Today we're going to be going over the pros and cons of taking adults with IDD to strip clubs with their care providers. And it's going to have the Oregon DH rule citations as well. This video is not about judging adults with disabilities for having adult interests. It's about what Oregon law actually requires when adults with intellectual and developmental disabilities are taken to strip clubs by paid care providers. Today I'm walking through both the potential benefits and the very real risks using Oregon DHS rules, ISP requirements, and individually based limitations, not opinions. Adult rights and legal capacity. Under Oregon law, adults with IDD are presumed legally capable unless a court appoints a guardian. I'm getting guardianship for my son, so my son is safe, but this is something that cannot be allowed to happen for the rest of the IDD community. Oregon DHS rules governing developmental disability services are grounded in person-centered planning and self-determination. That's person-centered planning is kind of like the housing first model for the homeless people. They're kind of intertwined. All this stuff came together at the same time from what I've been studying. Under OAR Chapter 411, Division 004, individuals receiving home care and community-based services have the right to make informed choices, access the community, live adult lives consistent with their preferences. Denying access to adult spaces solely because of a disability can be discriminatory. I agree. Pro 2. Person-centered planning and inclusion. Oregon's HCBS rules require that services be driven by the individual, not staff comfort. Under OAR 411-004-0020, person-centered planning, ISPs must reflect on what is important to the individual, support community integration, and avoid unnecessary restrictions on liberty. From this perspective, some argue that supporting access to adult entertainment is part of treating adults as adults. That's what I got told. Number 3, Pro 3. These are all the pros so far. We're doing the pros first. Structured support can reduce certain risks. Supporters argue that staff presence may provide transportation, assist with money management, help de-escalate unsafe situations. Oregon rules do not prohibit adults from IDD from entering adult venues. However, this is where the analysts must become rule-based, not philosophical. The case against the activity where DHS rules raise red flags. Con 1. Now we're on to the things that my side of the story. Con 1. Power imbalance undermines informed consent. Care providers hold significant power over transportation, over schedules, sometimes over finances, over service documentation. Oregon DHS expects providers to protect individuals from abuse, neglect, and exploitation. Under OAR 411-004-0020 and OAR 411-325-0020, providers must ensure that choices are informed, voluntary, and free from coercion. When staff organize, promote, or attend strip clubs with clients, DHS may question whether consent was truly independent. They didn't question it. The ombudsman didn't question it. The state didn't question it. Apparently, I'm the only one questioning it. Okay, con number 2. Sexualized environments create foreseeable risks. I agree. Strip clubs are inherently sexualized, financially exploitive by design, built on blurred social boundaries. Under OAR 411-325-0020 1F, providers have a duty to identify foreseeable risks and address them proactively. For individuals with IDD, Foreseeable risks include misunderstanding sexual clues, financial exploitation, emotional harm, and increased vulnerability to grooming. Ignoring foreseeable risks is not person-centered. It's non-compliance. And as far as this increased vulnerability to grooming, I know of a young lady and one of the clients and one of the workers, care providers, and they're always in their pictures together. And that's the one that my son, that the client and the provider were talking about how much fun they had at the strip club the night before. My son never went to a strip club. Number 3, con 3. Group settings do not replace individualized planning. Oregon DHS rules require individualized planning, not group assumptions. And I don't know if they did that. I've been saying since the beginning, I'd like to know if this is on all their ISPs. Under OAR 411-004-0020, supports must be tailored to the individual, not justified by what others in the home are doing. A group outing does not remove the obligation to access. A group outing does not remove the obligation to assess each person's understanding, each person's comfort, each person's risk profile. Con number 4. Documentation is not optional. Under OAR 411-415, case management, I haven't looked up that law yet. I've looked up the others. And OAR 411-320, CDDP responsibilities, I don't think I've looked up that one either. Elevated risk activities must be discussed in the ISP. Risks must be identified. Safeguards must be documented. A strip club outing clearly meets the threshold for ISP discussion due to sexual content, money exchange, community safety factors. If it's not in the ISP, staff should not be improvising it. Con 5. Individually based limitations are the only lawful way to limit or manage this activity. Oregon has adopted federal HCBS standards for individually based limitations. Under DHS, IBL requirements implemented through OAR Chapter 411, Division 004, rights may only be limited based on documented individual risk. The limitation must be the least restrictive option. The individual must consent. The plan must be reviewed regularly. This cuts both ways. Providers cannot ban strip clubs without an IBL. Providers also cannot ignore risks without ISP or IBL documentation. Either failure can trigger DHS compliance concerns. And I don't know if they have those. I guess my lawyer will have to send for papers, evidence. Con 6. Professional boundaries and provider liability. Oregon DHS expects providers to maintain professional boundaries, avoid dual relationships, avoid situations that could reasonably be perceived as exploitive. Under OAR 411-325, governing 24-hour residential programs, provider interactions are evaluated for safety, dignity, freedom from exploitation. If something goes wrong, agencies and staff may face DHS investigations, APS reports, licensing consequences. Okay, Section 3. The only compliant middle ground. Grounded in a fern home. If this activity is even considered, Oregon rules require independent supported decision-making, not staff persuasion, ISP discussion before the activity, which I do know that they did that, but I don't think they put it in their ISPs. They sat around and talked about it as a group. I know that. Education on money consent and boundaries. Clear opt-out rights with no consequences. Staff who do not personally benefit from or sexualize the outing. How can you not sexualize an outing to a strip club? That's what it's all about. IBL documentation if rights are limited or risk is managed. Without these steps, this is no longer about choice, it's about rule violations. Conclusion. Rights do not cancel responsibility. Adults with disabilities have the right to live adult lives. Providers have the legal duty to protect against foreseeable risk. Oregon DHS rules demand both. Calling something person-centered does not excuse ignoring power imbalances, exploitation risk, or ISP requirements. If you've been told this is too uncomfortable to question, that is exactly why it must be questioned. Share this video because rights without safeguards are not empowerment. So there you go. I'm getting all my laws out there. I'm going to look into those laws, and you can look into those laws too. I might make a video on it. I have so much stuff to make videos on. I have not heard back from the attorney yet. I'll feel much more relieved once I get custody of my son. So that's your video for today. We're going to save the IDD clients from these weirdo care providers in Oregon who all think it's okay. It's not okay.